Good morning, good afternoon, good evening, good wherever you are. This is again Dr. Mizan of Mizan Coaching LLC. One thing I've noticed is that I say I have different introductions for like every single one of my videos. So I hope you guys are okay with that. It kind of keeps things fresh. But today we have a really cool article. Like this was published March 11, 2025 in NEJM, the New England Journal of Medicine, which is, as far as I'm concerned, it's extremely well peer reviewed. It's legitimate, but it's called A New Perspective on Medical Malpractice. And for those of you who know me, for those of you who don't know me, I'm Dr. Naheem Mizan, MD. I'm a licensed family medicine physician, and I run my own medical legal and medical coaching business. So if you want to work with us, our email is in the description. But basically, I help people, hospitals, clinics, learn about medical malpractice, personal injury, and basically with hospitals, I teach them how not to get sued, and with normal people, I teach them what their rights are. So I do a lot of patient advocacy, patient rights. I basically travel around the U.S. and I give talks on this. So figured, why am I not like I should make a YouTube channel because then everyone can like learn about this stuff. Okay, sorry about that. All right, so this article we're just going to read together, and I'm going to just give my thoughts as a certified medical legal consulting physician, because again, that's all I do. Like I have private clients that I literally just teach them what their medical legal rights are. Okay, a New Perspective on Medical Malpractice by Abigail Zuger, MD. A changing legal standard has given the nod to evidence-based practice. Again, I always tell people the only type of the only type of medicine you should be practicing is peer-reviewed evidence-based practice. And we all have colleagues, you might have done it yourself, I know I have, like you hear about some weird study from like I don't know. I'm from Bangladesh, so I could say that. Like some weird study in Bangladesh with like a sample size of like 2, and it says something like, "Oh, if you put garlic in your ear, it helps you with diabetes or something," right? So my recommendation is don't do those things. Like, I'm not your boss, but as like just as a medical legal consulting doctor, do not do those things because if it's not the standard of care, then an attorney can file a case. If a patient is injured, and then their attorney can file a case against you. So make sure that everything you do is evidence based, right? Okay. So almost all clinicians carry malpractice insurance, but few of us really understand the definition of medical malpractice, let alone how its specifics should inform our daily work. And those specifics are changing now. An influential legal think tank has just revised its definition of malpractice substantially enough that experts believe the repercussions will start percolating through the courts. Traditionally, the primary question U.S. courts have addressed in malpractice cases has been whether the clinician under investigation followed the custom of the profession. In other words, the court wants to know if the clinician provided customary care that other similarly qualified clinicians working in similar circumstances would have provided. So again, I don't know who Dr. Abigail Zuger is, but the term that she is looking for is standard of care. So that's the actual legal term. I don't know what this custom of the profession, I've never heard of that before, but so the actual medical legal vernacular is standard of care. So we care about standard of care and then causation. And then finally, we have damages. So that's what they mean by custom of the profession. So standard of care, if you've watched my other videos, I highly, highly recommend that you watch my old videos where I don't have a microphone and it sounds tinny. But it's full of very useful information. So standard of care, the way that I define it, is with that particular patient. So let's say it's pneumonia. A patient comes in with a cough, a fever, chest X-ray shows possible, consolidations. You think it's pneumonia. Fantastic. What standard of care means, like if you were the hospitalist physician, what would 90% of your people do? So like 90% of all internal medicine hospitalists, what antibiotics would you give? Would you give IV fluids? What would you do in that situation? So that is deemed standard of care. So it's like, the normal distribution curve, it's the middle 90%. So we don't, if you're incompetent, like if you're in the left 10%, or if you're like a super amazing, doctor who knows everything, you're in the top 10%, you're not in the standard of care, right? So the standard of care is over here. If you do fall below the standard of care, there's you have liability now. So then, like, there could be, and then if there's causation, like something bad happened, there's damages, boom, that itself is a medical malpractice case just waiting to happen. Okay, so that's what standard of care means. It's like, what would your profession do in a particular situation? And that's like 90% of your people would do it. Okay. um Great. So in May 2024, the American Law Institute, an influential association of legal scholars analogous to the National Academy of Medicine, voted to change the adjective describing legally acceptable care from customary to reasonable. That tiny change in wording has sizable implications. Reasonable medical practice, in the words of the ALI, denotes the care, skill, and knowledge regarded as competent among similar medical providers in the same or similar circumstances. A more intuitive way of understanding the new wording might be this: it changes the legal standard of good medical care from what everybody else is doing to what everybody else knows, or perhaps should know, they should be doing. In a short readable review in JAMA, JAMA, directed at clinicians, the authors point out that the new wording formally acknowledges that modern evidence-based standards for diagnosis and patient management have a place in determinations of a clinician's competence. They emphasize that to have legal merit, evidence-based guidelines must be legitimate and authoritative, and they do not necessarily override the specifics of a given case. A failure to follow guidelines does not by itself indicate medical negligence. Still, the new wording indicates that acceptable medical practice generally requires a clinician to abandon antiquated and dangerous clinical habits, even if it is not yet common practice in the community to do so. So beautiful, like excellent work, Dr. Zuvier. Like, this is literally what standard of care means. So, and I love how she wrote it in such a like understandable way for doctors, because like, I work with hundreds of doctors, and it's like, and I am a doctor, right? So, but the thing is, like, when all you do is clinical medicine, your brain becomes just so honed in on, like, patient management, medical management. You don't have the privilege of like thinking outside of the box, right? Because all you care about is like keeping this patient alive, or like treating their illness and sending them home at their baseline. That's it. Like, the thing with the doctors is that the healthcare system in America and really all over the world is so freaking stressful and like just like soul wrecking that you don't have, like, most doctors that I know don't really have like skills in other sectors, and it's designed in this way where it's like medicine takes everything from you. Like, it takes your health, it takes your energy, it takes your mood. um is it fulfilling? Of course it is. Like, it's a beautiful privilege to be a physician. But again, like, the problem is that, like, you're so in a silo that you're not able, like most of my physician friends, like, they're woefully financially illiterate. Like, they don't know the difference between a Roth IRA and a traditional IRA. And it's like, I have friends that are like, I have a friend who's a mechanic, and he knows so much about like other things, like, he knows. Yeah. So the reasoning why, and so it's like, have some I don't know, sympathy for us doctors, because it was only after I left clinical medicine that I started to, like, explore other things. Like, I explored other, I started reading more books. I started, going to lectures. I started learning about things that I just never really knew about. But yeah, so the life of a doctor is um, it's extremely stressful. So this was a brilliant paragraph. Like kudos to Dr. Zubair. Um, okay, so finally, so continuing with the article, if courts begin to accept the legitimacy of evidence-based standards, clinicians might begin to practice less defensively. The review authors cite a well-publicized lawsuit from 20 years ago in which a third-year family medicine resident saw a man in his 50s for a routine physical exam. The patient and doctor discussed the pros and cons of routine prostate-specific antigen PSA testing. I have so much to say about this, as newly advised by evidence-based guidelines, and the patient did not undergo the test. A few years later, the patient saw another doctor. A PSA test was ordered without discussion, and the patient was diagnosed with advanced incurable prostate cancer. The patient sued and won. The first doctor subsequently wrote that at the trial, the plaintiff's lawyer. Okay, sorry. The patient sued and won. The first doctor subsequently wrote that at the trial, the plaintiff's lawyer threw evidence-based medicine around like a dirty word, vilifying it as a cost-saving method. The authors note that the new standard of reasonable practice means that a verdict that dismisses guideline-based care now would be unlikely. If in fact that is the case, many of the disproven tests and treatments that are employed now primarily to avert litigation might begin to disappear. And I think I have a video on what is defensive medicine, so I highly encourage you guys to watch that. Malpractice law is almost entirely state-based and often differs from state to state. As an independent national organization, the ALI seeks to synthesize quantities of sometimes discordant legal opinion from all over the country into coherent statements, in very much the same way, fittingly enough, that medical societies seek to process sometimes discordant studies into evidence-based guidelines. The ALI's new malpractice standard might be adopted just as slowly as the guidelines it endorses, but still it is a beginning. So brilliant, brilliant article. So, okay. So again, in human language, like what is this saying? So the case against that, that doctor about the PSA testing. So right now, like, and ever since, this was back in 20 years ago. Okay, so that makes sense. So right now, the USPSTF, or the United States Preventative and Screening Task Force, I believe. And it's all online, by the way. You can look up the USPSTF guidelines on anything. So for prostate cancer screening, we now do not recommend it, like, at all. Like we actually, it went from shared decision making. It went from, like, checking it regularly to this sort of, like, shared decision making, to now it's sort of like if the patient really, really wants it, like, then, you need to document it and then order it. So the reason why for prostate cancer screening is there have been so many false positives. And so if there's a false positive, we have to do a biopsy of a prostate. And so that can lead to a lot of issues. Like, it can lead to urinary incontinence. It could lead to anorgasmia. It could lead to a lack of ejaculation. Like, it can lead to a lot of genitourinary problems. And that's what's been happening over the past, like, few decades. So now the USPSTF is like, look, like, unless a patient has symptoms of prostate cancer, we're not going to do this anymore. So that actually happened because there have been so many injuries from the testing itself. So this is really cool because, I guess, like, 20 years ago, like, MedMal was, it was just like, oh, well, they should have done this because the guidelines say this. But that family medicine resident, who I'm sure is, like, is way older than me and much more, advanced. And, so I'm sure that doctor, like, that doctor was ahead of his time. That's what I'm saying here, because it's like back then, like, we didn't have these rules. And so what this article is saying and what this change is saying is that, look, like, even if there are guidelines to things, like, doctors are human beings, right? Like we are making decisions in a dynamic environment. So even if the standard of care says, give this guy IV fluids because he has whatever, like an electrolyte abnormality, it's like, as a doctor, I know that he has congestive heart failure, right? Or that, like, I just gave him fluids, and if I give him more, he's going to get pulmonary edema. So now what this article is saying is that doctors now don't have to practice defensively anymore. Like, we don't have to just, like, give everything under the sun because we're scared of getting sued. Like, what this is saying is that, like, now there's legal basis, which I'm extremely happy about. Like, now there's legal basis that you just have to do what's reasonable. And as long, again, CYA. Okay, so cover your behind. So I have like 3 videos on how to document appropriately. So please watch those. But like basically, this is saying that like as long as you do something medically reasonable for that patient at that time and you justify it, it is defensible. Sorry, like you can defend it. Like if someone sues you, because everyone's gonna get sued. Okay, like if you're a doctor, you will get sued. Okay, like that's just part of it. You'll either be named as the primary defendant, or you'll be part of some like giant catch-all shotgun method. Um, it's gonna happen. So I'm extremely happy with this new ruling. And this article is fantastic. Again, it's called. I just downloaded it from the NEJM website. You need an active subscription, so that's why I'm not linking it, because of what's the point. But again, it's from the New England Journal of Medicine, and it's called "A New Perspective on Medical Malpractice," and the author is Abigail Zuger, MD. Brilliant article, excellent job, and I'm a medical legal consulting doctor. This tracks, like this 100% makes sense. So yeah, so hopefully we're going to see less frivolous medical malpractice lawsuits, and doctors can practice a lot more with a lot more relief or like less stress, hopefully. But yeah, so that's my time for today. Thanks for watching. Hope you learned something. And if you have any comments, leave comments, like and subscribe, share. And if you do have any if you do have any video topics, leave them in the comments, and we'll be sure to make a video. All right, take care. Until next time. Bye.